To.
Mr Speaker.
Honourable Leanne Dalziel.
Mr Speaker, I too rise to speak in the second reading of a bill that had its first reading 1 year and 4 days ago. It was reported back from the Justice and Electoral Select Committee, which I serve on, 6 months later on the 8th of June 2012. So, in fact, our Select Committee, ably chaired by my colleague across the House, Tim McIndoe, well, at that time, and unfortunately hasn't been able to see its conclusion, and probably felt that he would have seen it traverse its full passage through the House by the time, given how prompt we were in actually reporting back within the time frame set by the Minister when it had its first reading just over a year ago. So the question that I've got is, why has it taken so long to come up the order paper, given the degree of urgency with which it was expressed in the first reading contribution from the Minister herself? And in fact, she spoke at some length about the need to progress this element of the Law Commission review on privacy legislation and rather than to await the detailed analysis of that report and all of the recommendations that would flow from that. And so I sort of thought, well, maybe I'd give it a go because she didn't mention it in her contribution, and I guess I didn't expect her to. But maybe the government doesn't want privacy or matters of information sharing, particularly, to be debated in Parliament. And I'm not surprised that this debate's occurring at 8:30 on a Tuesday evening. I suspect that has something to do with their not wanting to have a debate around these matters. And I just thought of a few cases that I thought I might just address. How about ACC? I think ACC would be a really, really good example. And so the ACC particular example that I was going to use was Michelle Bogue. Now, Michelle Bogue made this statement. Now, Michelle Bogue, as a former president, as my colleague points out, as a former president of the National Party, she stated this, and I just think this is a very helpful contribution to this debate. When you can't send a communication to a government minister without fearing that the privacy of that communication is going to be breached, that's very dangerous. Now, to which minister do you think that Michelle Bogue, ex-president of the National Party, was referring when she said, when you can't send a communication to a government minister without fearing that the privacy of that communication is going to be breached, that's very dangerous? Who was she talking about? No, it wasn't Paula Bennett, and it wasn't Tony Rowe, it wasn't Anne Tolley. Have we got any advances on those particular ministers? It was Judith Collins. I have to actually declare the fact that she was in fact referring to Judith Collins. Michelle Bogue was very clear about who she was referring to. And then there is another set of particular organisations or another minister that might like to not have the question of privacy breaches and information sharing, that wouldn't like to have that brought up in this House. And let me consider the role of one Paula Bennett releasing the private details of two women receiving a benefit after they spoke out against cuts to the training incentive allowance, a benefit that she herself benefited from when she herself was in that situation. And so she was so concerned that these women were daring to suggest that they were finding it difficult to get through a tertiary education without the benefit of the training incentive allowance that the Minister for Social Development got the benefit of. She in fact decided that that gave her the right to expose all of their private information about what benefits that they were receiving through the state system, through work and income. Now, of course, the privacy complaint system upheld that this was a breach of the individual's privacy, but as Paula Bennett herself said in response to that, I do not accept that view.
That was what she said. I do not accept that view. And then she was asked the question whether she would rule out releasing other people's information. What do you think the Minister said in response to that? Well, depending on the circumstances, yeah, I'd make a call on what I did at the time. I'm 4 years in the job now. I'd make another look at it and make a decision based on what the recommendations are and the rules around privacy.
Not very definite, is it?
She's just absolutely unclear about it, and I think that's why we're debating this bill over 6 months. 6 months after it was reported back from the Select Committee. They wanted to sort of shuffle it out of the way and try and get it through without any particular focus being brought to bear. And of course we had the blogger Ken Ng, who of course discovered that there was a little problem in work and income again with some problems that we had in that particular area. And of course well, NovaPay. Shall we mention NovaPay as well? Because, of course, the breaches of privacy with NovaPay are actually legendary. They actually outweigh a number of the other. They actually set new, very low standards, Ms. Dyson. I think it would be they've sunk to new levels of incompetence with the NovaPay system. But the point is that I think that this government has been rather unfortunate in trying to actually put to one side a piece of legislation which, yes, we have put up a minority report on it, but we are supporting the bill through the House because, as the Minister quite rightly said, there were 20 submissions. 18 of the submissions supported the bill in part or full, and of course the Privacy Commissioner supports the bill as well. So we are supporting the bill through the House, but I think that if the government was actually sincere about the urgency with which they wanted to attend to this particular matter, rather than dealing with the entire Law Commission report, which is what they told this House, then we would have had this dealt with before the end of last year. So I just want to put on record our minority view with the reporting back of this bill. Labor believes in an effective and efficient public sector. We agree that that is an important motivation in terms of this legislation. The swift sharing of information between public sector agencies, accompanied by appropriate safeguards, is an important component of this. But, and I think this is the important but, this bill takes a piecemeal approach to dealing with information sharing and may not stand the claims that have been made as to the need for it. And I think the fact that we've had it delayed for 6 months shows that that was an accurate assessment of our position. In particular, it is unlikely to do much to enhance the protection of vulnerable children. And again, that was something that was brought up by the Minister in her original speech in the House when she introduced the bill 12 months ago and 4 days. We agree with the New Zealand Law Society and with other submitters that there are better approaches than simply enacting some cherry-picked aspects of the Law Commission's review of privacy law. A standalone statute dealing with the welfare of vulnerable children when they are most at risk is a preferable approach. We would have preferred to see a standalone statute for the protection of at-risk children, accompanied by the complete enactment of the recommendations arising out of the Law Commission's review of the Privacy Act. Now, I have to say that that standalone statute concept was actually supported by the Children's Commissioner, and so it does actually have quite widespread support throughout the sector. This would have ensured that our privacy legislation, now nearly 2 decades old, is up to date with technological developments, changing social mores and the barriers to ensuring safety of the most vulnerable in society. A comprehensive rewrite of the Act on the basis of all of the Law Commission's work is essential. In particular, we are concerned that some of the Law Commission's key suggestions, such as those regarding the Privacy Commissioner's power to investigate and enforce, may not be taken up by the government. Given the ever-widening powers of agencies to share information, let alone the implications of new technologies, it is important that the Commissioner's role allow her to ensure compliance with up-to-date legislation. We will support the bill because we do not think it is likely to actively cause harm. However, we think there are alternative approaches that could have done much good. And I believe that that really sums up the opposition's position, which is why we will support this bill through its remaining stages.
Scott.